Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Advait Hattangadi. He graduated his law from New Law College in the year 2020. He graduated his LLM from Chembur Karnataka Law College in the year 2024, specializing in constitutional and administrative law. His areas of practice are primarily in the fields of banking and commercial laws. Today, Advocate Advait is going to speak on SEBI Prohibition of Insider Trading Regulations 2015. So without wasting further time, I would request Advocate Advait to commence with his lecture. Thank you.
Hello everyone. Today I will be speaking on the topic of the Securities and Exchange Board of India Prohibition of Insider Trading Regulations 2015. Now before I go into the topic, I would like to briefly give a background about the Securities and Exchange Board of India and how the Prohibition of Insider Trading Regulations came in place. So the Securities and Exchange Board of India, or SEBI, was established in the year 1988 as and by way of an executive resolution of the central government, which was later followed by the passing of the Securities and Exchange Board of India Act 1992, with the objective to protect the interest of investors in securities and to promote the development of and to regulate the securities market. According to Section 11 of the SEBI Act, it is the duty of SEBI to protect the interest of investors in securities and to promote the development of and regulate the security market by such measures as it thinks fit. Now, one of the important measures which has been stipulated in the said section effectively includes to provide a framework for prohibition of insider trading in securities. Further, under Section 12A, clauses D and E of the SEBI Act 1992 prohibit insider trading and dealing in securities by persons while in possession of material or non-public information or communication of such material or non-public information to any person in a manner which is in contravention to the provisions of the SEBI Act or the rules made thereunder. Further, Section 30 of the SEBI Act has empowered SEBI to make regulations consistent with the provisions of SEBI Act and the rules made thereunder. Therefore, in exercise of the powers conferred under Section 30 of the SEBI Act 1992, SEBI has framed the Securities and Exchange Board of India Prohibition of Insider Trading Regulations 2015 in order to put in place the framework for prohibition of insider trading in securities and to strengthen the legal framework thereof. Now, what is insider trading? The term insider trading has not been defined under the SEBI Prohibition of Insider Trading Regulations 2015, but it is an amalgamation of two terms, namely insider and trading, which have been defined by the said regulations. Now, on a bare perusal of the said term, it can be said that insider trading in simple terms would mean trading in securities which is carried out by a person who is an insider. The term insider is defined under Regulation 2, Sub-Regulation 1, Clause G of the said regulations to mean a person who is a connected person or any person who is in possession of or having access to unpublished price-sensitive information. Connected person under Regulation 2, Sub-Regulation 1, Clause D of the said regulations means any person who has or has been during the 6 months prior to the concerned act, that is the act of trading in question, associated with a company in any capacity, either directly or indirectly, not only by way of a contractual, fiduciary or employment relationship, or by being a director, officer or an employee of the company, or holding any professional or business relationship, but also by way of and by reason of frequent communication with its officers, which allows such a person direct or indirect access to unpublished price-sensitive information or is reasonably expected to allow such access. Further, Subclause 2 of Clause D of Subregulation 1 of Regulation 2 specifies 12 categories of deemed connected persons, which inter alia include relative or relatives of connected persons as discussed before, a person sharing a household or residence with a connected person, or even a firm or its partner or its employee in which a connected person specified in subclause 1 of clause D is also a partner. Another crucial definition and concept in the SEBI Prohibition of Insider Trading Regulations 2015 is the concept of unpublished price sensitive information. Regulation 2, Subregulation 1, Clause N defines unpublished price sensitive information to mean any information related to a company or its securities, directly or indirectly, which upon generally becoming available is likely to materially affect the price of the company's securities and shall ordinarily including but not restricted to include information relating to the following, that is the financial results, dividends, changes in the company's capital structure, mergers, demergers, amalgamations, delisting, disposals and expansion of business and such other transactions, and changes key managerial personnel of the company as defined under section 2 subsection 51 of the Companies Act 2013. Now, insofar as mutual funds are concerned, Regulation 5B, Subregulation 1, Clause F defines unpublished price sensitive information to mean any information pertaining to a scheme of a mutual fund which is not yet generally available and which, upon becoming generally available, is likely to materially impact the net asset value or materially affect the interest of unit holders and shall include instances where there is a likelihood of change in the accounting policy, a material change in the valuation of any asset or class of assets, restrictions on redemptions, winding up of a scheme or schemes, creation of a segregated portfolio, the triggering of the swing pricing framework and the applicability of the swing factor, material change in the liquidity position of the concerned mutual fund schemes, and default in the underlying securities which is material to the concerned mutual fund schemes. And last but not the least, trading has been defined in Regulation 2, Subregulation 1, Clause L to mean and include the activity or activities of subscribing, redeeming, switching, buying, selling, dealing, or agreeing to subscribe, redeem, switch, buy, sell, deal in any securities. The SEBI Prohibition of Insider Trading Regulations 2015 broadly prohibit two kinds of activities, namely communication or procurement of unpublished price sensitive information under Regulation 3 and trading by persons who are in possession of unpublished price sensitive information under Regulation 4 of the said regulations. Regulation 3 of the SEBI Prohibition of Insider Trading Regulations 2015 states that no insider shall communicate, provide, or allow access to any unpublished price sensitive information relating to a company or securities listed or proposed to be listed to any person, including other insiders, except where such communication is in furtherance of legitimate purposes, performance of duties, or discharge of legal obligations. Similarly, no person shall procure from or cause the communication by any insider of unpublished price sensitive information relating to a company or securities listed or proposed to be listed, except in furtherance of legitimate purposes, performance of duties, or discharge of legal obligations. The term legitimate purposes has also not been defined under the said regulations, and therefore a duty has been cast upon the board of directors of listed companies to make and formulate a policy for determining what are legitimate purposes as part of the Code of Fair Disclosure and Conduct formulated under Regulation 8, and a person in receipt of unpublished price sensitive information pursuant to a legitimate purpose shall also be considered to be an insider under the SEBI Prohibition of Insider Trading Regulations. Regulation 4 of the said regulations casts a bar on trade in securities that are listed or proposed to be listed on a stock exchange when such a person is in possession of unpublished price sensitive information or by persons who are otherwise insiders. However, the prohibition under Regulation 4 is not absolute in nature and excludes from its ambit 6 kinds of trades specified in the proviso of Regulation 4 Sub-Regulation 1, namely, number 1, off-market interest transfer between insiders in possession of the same unpublished price-sensitive information without being in breach of Regulation 3 and where both parties had made a conscious and informed trade decision. Number 2, transactions carried out through the block deal window mechanism between persons who were in possession of the unpublished price-sensitive information without being in breach of Regulation 3 and again where both parties have made a conscious and informed trade decision. Number 3, transactions carried out pursuant to a statutory or regulatory obligation to carry out a bona fide transaction. Number 4, transactions undertaken pursuant to the exercise of employee stock options in respect of which exercise price was predetermined in compliance with applicable regulations. Number 5, now in case of trades by non-individual insiders such as companies and LLPs, the individuals who are in possession of such unpublished price-sensitive information were different from the individuals taking trading decisions, and such decision-making individuals were not in possession of such unpublished price-sensitive information when they took the decision to trade. Appropriate and adequate arrangements were in place to ensure that these regulations are not violated and no unpublished price-sensitive information was communicated by the individuals possessing the information to the individuals taking trading decisions, and there is no evidence of such arrangement having been breached. And finally, number 6, whether trades by insiders have been carried out in accordance with the trading plans set up under Regulation 5 of the said regulations. Under Regulation 5 of the SEBI Prohibition of Insider Trading Regulations, if an insider under these regulations wants to carry out a trading activity in the company's securities, he shall prepare a trading plan which shall be subject to the company's compliance officer and subsequent public disclosure, after which he will be permitted to carry out trade in the company's securities. While formulating such a trading plan, the insider shall take in mind some following parameters, such as the trading plan shall not entail commencement of trading earlier than 120 days from the public disclosure of the plan, and set out the details or parameters of the trade to be executed, that is, either the monetary value of the trade or number of securities to be traded, the nature of the trade, the specific date or time period of the trades which shall not exceed 5 consecutive trading days, and an optional upper price limit for a buy trade or a lower price limit for a sell trade. Further, it is also necessary to ensure that the trading plan shall not be overlapping with any already existing trading plan and should not entail trading in securities for market abuse. When the trading plan is submitted by an insider, the compliance officer of a company may also ask the insider for certain written undertakings before approving the trading plan. And once a trading plan stands approved, the trading plan becomes irrevocable on part of the insider, and the insider is mandatorily bound to execute the trades as per the trading plan without any deviation from the same, except, however, in cases like permanent incapacity, bankruptcy, or operation of law. Now, this was the main aspect and about insider trading under the SEBI regulations. Now, what is the penalty if someone engages in insider trading? Section 15G of the SEBI Act 1992 prescribes a penalty which shall not be less than 10 lakh rupees, but which may extend to 25 crore rupees or 3 times the amount of profits made out of the insider trading, whichever is higher, upon persons who communicate or procure unpublished price-sensitive information in violation of Regulation 3 or engage in insider trading in violation of Regulation 4. The reason behind providing such a huge quantum of penalty is to create a deterrent for the public at large from engaging in insider trading activities and to protect the investors and fair trading activities as a whole in the capital and stock markets. When someone is caught or otherwise accused of engaging in insider trading activities, first of all, such person would be subject to civil proceedings which will be instituted before the adjudicating officer of SEBI appointed under Section 15I of the SEBI Act 1992, along with criminal proceedings before the special SEBI court set up under Section 26A of the SEBI Act, which is equivalent to a court of sessions. when a criminal complaint is filed by SEBI before the SEBI special court and taken cognizance thereof, and after the special court, upon finding that the accused is indeed guilty of violations, the special court has the power to award imprisonment up to a term of 10 years or a fine up to rupees 25 crores or both, depending upon the nature of the violations and loss caused to investors and securities market at large. Now, once proceedings are instituted, civil or criminal, as whatever they may be, upon whom does the burden of proof lies in cases involving violations of SEBI Act and otherwise insider trading regulations? Now again, the insider trading regulations have created special rules of evidence providing burden of proof in cases of insider trading, which are in addition to the provisions which are contained in the Indian Evidence Act or the now Bharatiya Sakshya Adhiniyam. Now the onus of showing that a certain person was in possession of or had access to unpublished price sensitive information at the time of trading would be on the person leveling the charge, after which the person who has traded when in possession of or having access to unpublished price sensitive information may demonstrate that he was not in such possession and that he has not traded or he could not have access, or that his trading was when in possession of such information was squarely covered by the exonerating circumstances. Further, in case of connected persons, the onus of establishing that they were not in possession of unpublished price sensitive information shall be on such connected persons, and in other cases the onus would be on the Securities and Exchange Board in appropriate proceedings. Now, once the proceedings are conducted, once the matter is heard and a verdict is reached at, if a person is aggrieved by the order passed by the adjudicating officer, he has the liberty to prefer an appeal before the Securities Appellate Tribunal within 45 days from the date of receiving the copy of the order, and a person who is aggrieved by the judgment and order passed by the SEBI Special Court can prefer an appeal or a revision application before the Honorable High Court having territorial jurisdiction over such special court in accordance with the provisions of the CRPC or the new Bharatiya Nagarik Suraksha Sanhita. Further, if a person is still aggrieved by the order passed by the Securities Appellate Tribunal or SAT, the aggrieved person can prefer an appeal against the order of SAT before the Honorable Supreme Court of India within 60 days from the date of communication of the decision or the order of SAT on him on any question of law arising on such order. Therefore, if a person is aggrieved with an order of SAT and he wants to prefer an appeal to the Supreme Court, the appeal can lie before Supreme Court only and only on point of law. Now, the SEBI Act also has created a special mechanism for the purpose of settlement and composition of civil and criminal proceedings for violations under the SEBI Act. Now, for a matter which is pending before the adjudicating officer, a person against whom proceedings may have been initiated or against whom proceedings may be initiated may file an application in writing to the Securities and Exchange Board proposing for the settlement of proceedings initiated or to be initiated. Upon receipt of such an application, the board may, after taking into consideration the nature, gravity, and impact of defaults, agree to the proposal of settlements on payment of such sum by the defaulter or on such terms and conditions as may be determined by the board in accordance with the regulations made under the SEBI Act 1992. And upon payment of such fees and penalties, the proceedings before the adjudicating officer shall accordingly be discontinued. So far as criminal proceedings before the SEBI Special Court are concerned, or an appeal before the SAT is concerned, an offence punishable under this Act not being an offence punishable with imprisonment only or with imprisonment and also with fine, may either before or after the institution of any proceeding be compounded by the Special Court or the Securities Appellate Tribunal before which such proceedings are pending, subject to the views provided by the Securities and Exchange Board with respect to the compounding before the concerned court or SAT. Now, Section 24A of the SEBI Act does not provide any specific guidelines as to what parameters have to be considered for providing the views or what are the considerations or under which the offences or activities otherwise prohibited may be compounded. The Honorable Supreme Court, in the case of Prakash Gupta versus SEBI, has laid down the following guidelines which shall be followed by the SEBI Special Court or the Securities Appellate Tribunal, as the case may be, while considering compounding applications filed before them. First of all, they should consider the factors which are enumerated in SEBI's circular dated 20th of April 2007 and the accompanying FAQs while deciding whether to allow an application for consent order or an application for compounding. While these factors are non-exhaustive, some of the indicative factors and parameters to consider include whether the violation was intentional, the party's conduct during the investigation, and whether the party has disclosed all facts truly, the gravity of charges that are leveled against the party, that is, charges like fraud, market manipulation, or insider trading, whether the accused person has a history of non-compliance, good track record of the violator, that is, if he has not been found guilty of similar or serious violations in the past, whether there were circumstances beyond control of the party, what is the consideration of amount of investors' harm or the party's gain, the processes which have been introduced since the violation to minimize future violations and lapses, any compliance schedule if the party proposes, economic benefits accruing to a party from the delayed or avoided compliance, satisfaction of claims of investors regarding payment of money due to them or delivery of securities to them. The principle behind compounding under the SEBI Act 1992 is to ensure that the aggrieved party has been restituted by the accused and it consents to end of the dispute. Since the aggrieved party is not present before the Securities Appellate Tribunal or the SEBI Special Court, and most of the offences are of a public character, it should be circumspect in its role that the SAT or the Special Court, as the case may be, rely upon SEBI's opinion as to whether such restitution has taken place. And further, the SAT or the Special Court should also consider whether the offence which has been committed and which is before issue is of a private nature or if it is largely of a public character, and whether the non-prosecution of the said offence will affect others at large. As such, the latter should not be compounded even if the restitution has taken place. And with this, I hereby conclude my presentation, and I would like to thank Team Hammurabi Tablet for giving me an opportunity to speak on this topic. Thank you.
Advait, thank you very much, because this was a very specialized topic, and as the lecture, you could find that it had lot of technical insights, especially for people who are not practicing in SAT or who are not aware about this particular act. So I think it's a nice overview which we have given to the viewers who would understand this particular act. So thank you very much, and a small token from Hammurabi to you.
Thank you, sir.